Good morning, everyone. Happy Friday. Thanks for those of you who are back. If you were not on the last SNT webinar, you might want to watch that one. There's a link to it on NewYorkHealthAccess.org. You can also reach it by just Googling NILAG on YouTube. I'm just starting out here with a corrected slide, and these have now been posted on NewYorkHealthAccess.org. Thanks to Lynn Decker at Sydney for pointing out some changes in ABLE. You can deposit $15,000 now instead of $14,000. It will probably go up next year as well. And also, there's a special rule for people who are working. If they are disabled and working, they can also deposit more. They can deposit some of their earned income up to the federal poverty line, and that also changes every year. If you got my email with the corrected PowerPoint, there was a technical difficulty and my changes were not saved in that PowerPoint. So please don't rely on that one. Download the new one from either GoToWebinar here, it's there as a handout, or our webpage. All right, and now we'll go on to part 2, which is using SNTs for a lump sum. So we're building on what we learned in the first program. And one thing you learned in the first part is that these rules are not one size fits all. We're going to address each benefit one by one. First Medicaid, then SSI, then veterans, then some of the housing subsidies. The rules are just not the same. And even within Medicaid, they are not the same because we have different types of Medicaid for different categories of people. So some review about that. The main clientele of people participating in this webinar are either elderly, age 65 or over, or have been determined disabled. So that is the group in one type of Medicaid, and they have an income limit that's in the chart, and they have an asset limit that's in the chart. And many people think that's the only kind of Medicaid because that's their main clientele. But it's just one group of Medicaid. And for this group, if they have income over the limit, they can spend it down. And that's why we talked about pooled trusts as a way of eliminating that spend down. And a pooled trust can also be used to deposit excess assets above the Medicaid limit, and an individual trust if you're under 65. So one of the strategies we want to think about when we're talking about someone who would have excess income or excess assets is to think about, well, could that client be in another category of Medicaid? And this we call the MAGI Medicaid category. And these are people eligible under expansion Medicaid under the Affordable Care Act, also known as Obamacare. And MAGI stands for Modified Adjusted Gross Income. If you've done your own taxes or know anything about tax, that's a familiar term, AGI, and that's because this type of Medicaid uses the tax rules as the basis for what counts as income, but they're modified from the tax rule, and hence we have MAGI instead of AGI. So who could be MAGI? And then we'll talk about why it might be advantageous to put someone in this bucket. So if they're under 65 and not on Medicare, I mean, that's the main definition of this group. So that's why this is millions and millions of New Yorkers. It's all children, all adults under 65 who are not on Medicare. So it's families and singles and couples. So it's the vast majority of Medicaid recipients. and it includes people on SSD in their 24-month waiting period for Medicare. So it can also include even people over 65 or under 65 who have Medicare if they're a caretaker relative for a minor child. And that could be a grandchild or other relative. It cannot be a foster child and it can't be a godchild. It must be related through adoption or blood. And child is defined as under 18 or under 19 if in school. So this could be an 85-year-old woman who's on Medicare, but she's caretaker for her grandchild who lives with her. So why do you want to think about this? Well, here's just another chart illustrating who's always MAGI, and that's in this top group, children and adults under age 65, not on Medicare. They have no other option. This is the only thing they can be. The non-MAGI are age 65 and over, not caretaker relatives, or under 65 and on Medicare. And people receiving SSI are in their own special category. There's a group in the middle, the people who have a choice, and that's who we're talking about now. That's the people who are certified disabled and not yet on Medicare. They're in their 2-year waiting period for Medicare. Or they receive SSI, but they could decide not to receive SSI if they don't have Medicare. And if they get a nice big lump sum, they can decide, I'm dropping my SSI. I want to live on this and enjoy this money for a while. They can get MAGI Medicaid until they're 65 or get Medicare. So and then the caretaker relatives of any age, even those of us who work mostly with the elderly, need to have this on our checklist to see, could this person be eligible? And here's why. What's favorable? There is no asset limit with MAGI Medicaid. A lump sum received in the past or received this week does not impact current eligibility. Now, I just said this week, but I should talk about that because that's really income if you received it this week. So strike that, lump sum received in the past. So there's no asset limit. That's so different than non-MAGI Medicaid. And you can see for winning a lawsuit or getting a buyout from a landlord, this is huge. It means that can sit in the bank and it does not affect your Medicaid eligibility. Another advantage is that because it uses federal income tax rules for deciding what is income, certain things don't count as income that do count in the other Medicaid, the non-MAGI Medicaid for the disabled and elderly population. An inheritance is just simply not income. A gift is not income. So if mom is supporting, um, an adult child while when they lost their job and is writing a check to them for $2,000 every month, that's not income under this. So if they're 25 years old and not on Medicare, they can apply for MAGI Medicaid because they have that income isn't countable. Personal injury settlements follow the tax rules. They're generally not countable. Now, I am not an accountant or a tax lawyer, so this is like very broad strokes. You need to consult a tax professional, about whether any particular settlement would be taxable and therefore under MAGI. But I do know, generally, a personal injury settlement is not taxable. And this has been a planning tool that I learned from some of my elder law colleagues. They do structured settlements where someone receives, $100,000 a year from a personal injury settlement for many years, and as long as that person doesn't go on Medicare, which of course, or they have children under age 18 or under 19 in school, that doesn't count as income, and they're eligible for MAGI Medicaid. Veterans benefits do not count as income, and neither does workers' comp. So these are big differences from the other type of Medicaid. The other thing is there's higher income limits. For income that does count, compare for a single person, you're allowed to have 1,437 a month in income. That's 138% of the poverty line. Compare that to only 859 countable income for Medicaid for the older adult and disabled population. And couples the same. So you can see there's quite a big difference in income. Now, one thing is there is no spend down in MAGI Medicaid. If you are over those limits at the time your eligibility is being determined, you're not eligible. And that's when you think about purchasing a qualified health plan on the New York State of Health Exchange with premium assistance or cost sharing assistance. We're not getting into that, but those are all options for younger people and who are not on Medicare. Another big advantage of MAGI Medicaid is 12-month continuous eligibility. So this was a wonderful part of the ACA. For 12 months from the time one is determined eligible for this Medicaid or from a renewal, any income received during that 12 months will not affect eligibility. So if the lump sum is received during that year, that's okay. Or if that person got a great job during that year, that's okay. This was a wonderful part of the ACA because it recognizes that people's income can fluctuate and they want to make sure their health care is stable for at least a year. Now, at the next renewal, eligibility will be based on the income that's current then. So if someone did get a better paying job, they will probably have their MAGI Medicaid terminated at that time. But if they received a lump sum during the past year, that income is not deemed to continue because it was just received in that 1 month. So, you know, that's would not affect their eligibility. Even if they saved it, that's okay because remember there's no asset test. Now there's a few exceptions to these wonderful rules about the 12-month continuous coverage. And one is if the person turns 65, it just stops. It cuts off the 12-month eligibility. And the person will be transitioned to regular or non-MAGI Medicaid. Sometimes we call it regular Medicaid because those of us who do work for older people and people with disabilities, that's our regular. But it's non-MAGI Medicaid. Another exception is lottery winnings. They got very clever and passed a law that prorates a big lottery lump sum to deem it received like over a course of a number of years as opposed to uh, just at that one time. And these are lottery winnings, I believe, over $80,000. It's a very, and it's like it's the length of this prorated period depends on the amount received. And we got this information from the National Health Law Program Guide, and the sites are in our longer manual, our outline, which you have the links for. Now, in MAGI Medicaid, there are lump sums that would be countable. And again, this is primarily the tax rules. So a housing buyout, again, not tax advice, but I just did a little Google research and found this blog I'm giving you that says it's probably taxable. Again, big caveat there, not a tax lawyer. Again, the lottery winnings are going to be deemed income and ongoing and could disqualify someone from MAGI Medicaid. And, each type of lawsuit has to be looked at for whether it's taxable. Lost wages, contract claims, discrimination, employment claims are generally taxable. So those would be counted as income. But again, if they're a lump sum, if the settlement is counted as income, um, if it was only received in a lump sum, then you still have that advantage of the 12-month continuous eligibility so that the next year it wouldn't be part of your income at the time of renewal. If it was given in a structured settlement, though, over time, then it probably would knock the person off. So this is good information to know if you're planning on settling a case. You need to see, would this person otherwise be on MAGI Medicaid? And if so, would this be taxable? If so, you would not want to enter a structured settlement for that kind. But on a personal injury settlement where it's not taxable, a structured settlement is fine. Again, there's no one size fits all rules here. Now, for MAGI Medicaid, you also have to be thinking ahead. If your client is 64 and the only thing you remember from this seminar is, great, a lump sum is doesn't count as income and there's no asset test because this person's under 65, I'm going to tell them they can just keep it. Well, I would probably call your malpractice carrier because you need to be looking ahead. Is the client close to turning 65? If they are, yes, the lump sum won't terminate their MAGI Medicaid now, but in a few months when they turn 65, they get switched to non-MAGI Medicaid, and that's traditional Medicaid with the asset test. And now that 100,000 in the bank has to be dealt with. So you always want to think about a pooled trust or an individual S&T and get that money in there before the person turns 65. If if they're disabled, of course. Use of an S&T, remember from the first session, they must be disabled. It is not enough to just be getting Social Security. They have been determined disabled or be disabled by Medicaid. Now, if the client is under 65, let's say they're well under 65, they're only 40, you still have to think about, are they close to obtaining Medicare? Because they're nearing the end of their 2-year waiting period for Medicare if they receive SSD. Now, for them, the 12-month continuous coverage does apply so that they get this lump sum or they get, if it's paid out over time, um, that new income, even if otherwise it would be too much, too high, uh, does not disqualify them. But at the end of the 12 months of continuous eligibility, now if they have that asset in the bank, they will be switched from MAGI Medicaid to non-MAGI Medicaid. So you have to do asset planning. Again, think about an SNT if they have a disability, because no transfer penalty, right? We know that. Now, the other exception for MAGI Medicaid is even if they have Medicare, Even if people in these, if they're close to turning 65, they might not lose MAGI Medicaid because they have a 15-year-old child or grandchild living with them, or niece or nephew who are living with them and they're caretakers for. So they might not drop off MAGI Medicaid yet, but is that child or grandchild close to turning 18, or if they're in school, close to 19? Because again, then they lose their eligibility for MAGI Medicaid and they will be switched to non-MAGI Medicaid. So again, look at establishing an SNT. If that's going to require a court order for any reason, if the person lacks capacity, uh, then you want to get that motion filed and ask for it to be established nunc pro tunc before they turn 65. But this is not everybody. This is a lot of our population. But if you're doing lump sum planning for someone who's 40, is not disabled, and they're doing a housing buyout, or then they or winning a lawsuit for discrimination, they really can keep that money. And until they're 65 or close to getting Medicare, it's only then that they have to start thinking about planning for the transition. So if they are in that category, then, and they're not MAGI, so now we're going into the non-MAGI people. So they are 65 or over. They or younger than 65, and they do have Medicare, and they are not caretaker relatives for a minor child. So in that case, a lawsuit, settlement, or a lump sum is income in the month received. And if it's still in their possession into the next month, then it will count as a resource against the resource limits. And on that early slide in this section, we have the resource limits and the income limits. So your planning for them is going to take into consideration their age. I hope that you've learned that. It's absolutely critical to ask what's their age. If they're under 65, they have different options than if they're age 65 or over. If they're under 65, you have to know, are they determined disabled, or could they be if you filed documents with your local DSS or HRA to prove they're disabled? Are they receiving Medicare? What's the chance that they will need nursing home Medicaid in the next 5 years? This affects planning because if they transfer assets, they need to understand their risk that they will have a transfer penalty for nursing home Medicaid. And are they a caretaker relative, as we talked about before? So let's just talk about some strategies. What to do with a lump sum. Let's say your client's at home in the community on non-MAGI Medicaid. Many of us have clients receiving home care, managed long-term care, or they have Medicaid for other reasons. So there's generally a three-prong strategy: saving money, transferring money, and spending down money. So they can save up to the resource limit, which we have here. They can transfer. And I know like transfer is like a dirty word, but it's not a dirty word. Transferring excess assets is a common planning strategy. You just have to do it carefully and mindfully of the risk. And you have to advise the client of the risk that if they enter a nursing home in the next 5 years, if they're age 65 or over, and if they didn't transfer it into a trust, a pool trust, or a supplemental needs trust, a non-exempt transfer will trigger a transfer penalty. So what is that penalty? Basically, Medicaid won't pay for nursing home care for 1 month for every 12,000 plus transferred in the 5 years before the person was admitted to the nursing home and applies for Medicaid. Now, down at the asterisk in the footnote is the link to see the chart to see what's the penalty rate for every region in the state. Those will change in 2020. This is the New York City rate. So if someone transfers 25,000 in New York City, they know that for the first 2 months they're in a nursing home, Medicaid will not pay for their care. So the policy here is that Medicaid says, well, have your daughter who you transferred the money to pay for your care. Let her take that 25,000 and pay for it, or let her give it back to you and pay for it. That's what they want. They don't want to pay for it. They want you to use the transferred money to pay for it. Now, in the community, there's no transfer penalty, right? So you can transfer that 25,000 or 250,000 or even, 5 million in theory, although we wouldn't advise it, and apply for Medicaid the next month. Now, if you're already on Medicaid and you're doing this, you need proof that the money was transferred. This is just a very common question. People think they can just take 50,000 out of their bank account and show Medicaid that their account is under the limit. Well, Medicaid wants you to show where it went. They can assume that money withdrawn from your account is under your mattress. So how do you do that? You can show a canceled check or a wire transfer, direct account to account transfer to your daughter. And it's not an exempt transfer. That would incur a penalty if you went to a nursing home, but you're in the community, and so it can't be penalized. So they're not asking you where you transferred it because they're judging the transfer. They just want to know that it was transferred. So the third strategy is spending the money down. And one way is to buy exempt resources, a funeral agreement, prepaying the mortgage, buying a burial plot, buying other things, home improvement, clothing, furniture, travel. Let's see, a little sticky. So transferring is one of the strategies. Let's just look at generally at some of the exceptions to the transfer penalty. A transfer to one's spouse has no penalty if you go into a nursing home later. Of course, then you'll have to do planning in terms of the spouse, perhaps having excess assets, which we're not going into here. There are tools, spousal refusal, spousal impoverishment. That's another topic, but that is always one transfer strategy. Transfer to a child who is certified blind or disabled. And this can be done even if they're over 65. We once had a case of a 90-year-old client who had transferred some money to her 70-year-old daughter. Now, that daughter hadn't been determined disabled before she turned 65. So we had to ask Medicaid to certify her as disabled so that the transfer would be exempt. But they did. We were able to show she couldn't return to her former work as a home health aide. And so that transfer was exempt. If one is under 65, as I think you know by now, and the person's disabled, they can transfer it to their own individual supplemental needs trust with no transfer penalty, and that's true using an individual trust or a pool trust. If they're over 65, they can only use a pool trust, but there's no transfer penalty for community Medicaid. The other exemption is this last star here, whoops, that they may transfer it to a supplemental needs trust for someone else if they're under 65 and disabled. And that person does not need to be related to them. It could be their godchild, it could be their neighbor's kid, their niece. If someone's going into a nursing home and that money is basically going to be lost anyway on the nursing home care, maybe this is the time to set up a trust for that relative or friend who is under 65 and has a disability. But don't, and that would not have a transfer penalty. Now, Medicaid planning is complicated. This is just the barest bones of what these options are. There are many other trainings by State Bar and City Bar on Medicaid planning, but this is just you have a lump sum. What are some of your options? Spending down the lump sum, when these lump sums are not that great, say 20,000 or so, 25,000, you really want to think about just spending it down. The Medicaid limit allows you to keep 15,000 and change. So uh, let's say it's 40,000. It's not that hard to spend that extra money on prepaid funeral agreements, and Medicaid allows these agreements to be set up not only for yourself, but also for your spouse, your children, their spouses, and certain other family members. See our fact sheet here. You can pay down a mortgage. Excuse me. You can pay back bona fide loans, credit card debt for yourself. If you're paying off someone else's debt, that would be a transfer. Now, bona fide loan means you have some record of that. Uh, someone, you need a loan agreement that recites that you agreed to pay back money that was lent to you in a certain amount and it's over a certain time. Uh, home improvement, computer, travel. One thing people don't realize is they can prepay rent or utility bills. And this is a great thing to do if there's not, that much money. And you want to avoid a transfer penalty. So if you have it has to be a stable housing situation. You wouldn't want to prepay the rent in a month-to-month tenancy and then the next month get a notice terminating your tenancy and you're out of there. But if it's a stable landlord, they're happy to have your cash. You can pay a year's worth of rent. And as long as you have a receipt for that, that's not a transfer because you're paying for value. It's full consideration. Um, we'd suggest you make it irrevocable because Medicaid or SSI could scrutinize that and say, wait a minute, you're basically just setting up sort of like an escrow account for yourself with your landlord. And if you told your landlord you wanted it back, they'd have to give it back. So you could make it irrevocable, and that if any balance was left um, because you moved or died, it would be transferred to your estate or it would be transferred to your next residence. You have to get creative with that. But I did it once, and as a Social Security Administration didn't really ask for much. They just asked for the receipt. Now, people always ask, do I have to report a lump sum that I receive? Yes, you do. I mean, every benefit based on financial eligibility has a requirement to report. So the SSI rule is in the POMS. The sites that's their program manual, which is online. Sites are all in our big manual. It has to be reported by the 10th of the month following the month in which you've received the lump sum. Now, even though this is an SSI rule, Medicaid uses the same rule for the non-MAGI population. So that is people who are disabled, aged, or blind. And it's actually a pretty good rule because if you received $10,000 now in November and you were required to report it in November, your SSI or your Medicaid would be cut off because this month you're not eligible because you have excess income. So they made the rule say, no, we're going to only require that you report it next month. And we're going to let you bring down the asset to below the asset limit by the end of the month in which you received it. And if you've done that, you have preserved eligibility for the next month. So you're only ineligible in the month of receipt. And this rule says we're not going to cut you off, Medicaid or SSI, for just 1 month. Now, they might go after you for an overpayment, right? Pay us back, but that's a lot easier to deal with than having Medicaid or SSI discontinued. So let's talk about how this pans out on a practical matter. Except, so let's say Bob receives the payout in January, and as I said, he is not eligible in January for Medicaid, or the same would be true for SSI, but he doesn't have to report it in January. Ideally, he takes action in that same month to bring his resources down by the first of the next month. And that's what the 3 tools we said. He spends it, he saves some of it, he transfers some of it. So if his resources are under the limit by the first minute of the next month, then he's eligible for Medicaid and SSI, same rule, for the next month. So it can't be discontinued. All they could do is SSI could do an overpayment, HRA or DSS could sue for the cost of Medicaid in that 1 month. At least in New York City, they would just not do that. It's not worth their trouble. I don't know about other counties. Now, let's say it takes him another month to bring his resources down, which is very common, right? People just don't get it done. They don't even come to you till the next month or the next month. So, okay, now he's potentially liable for an overpayment for 2 months instead of just 1 month. But okay, DSS or HRI is still going to not consider it worth bringing a lawsuit to recover for the cost of services they provided. So whenever the person comes to you, we get a lot of people come pretty paralyzed from having received a check. Sometimes they haven't deposited it, an insurance payment, a settlement, uh, estate proceeds, and they're just scared. So you're doing damage control. You tell them, let's start the plan now. Deposit it, spend it, transfer it, and save the rest quickly. So the goal is to have eligibility secured for the following month. You're doing damage control. There's nothing you can do. Yes, they're vulnerable to having an overpayment claim for these past months ever since they received the check because it was available to them, but there's nothing you can do about that. If you help do SSI advocacy, they'll probably get an overpayment, and you can always try to challenge that or seek a waiver of recovery. And on these strategies, you don't have to pick one thing. You can combine them. You can put some of the lump sum into an SNT and transfer some of it and spend some of it. Don't think about that it has to be all or none. Also, when you're putting money in an SNT, you want to think about how much are they likely to spend during their lifetime, because the balance will stay in the trust after their death, or in an individual trust. It will be used to do the payback for Medicaid. So you don't want to take a $300,000 settlement and put it in a trust if the uh, you know person's quite elderly or quite sick, and not likely to spend it in their lifetime. So, an example of Bob receiving a $50,000 inheritance in January. He's 62, receives SSD, and he only has 3,000 in savings. So the inheritance is income in the month received. He's not eligible in that month, but he's not required to report it until the 10th of the next month. If he still has it on the first minute of February, it is an asset countable for February. But again, and in that case, if he came to me in February and he hasn't spent it down, I would advise him not to report in February. I would advise him to spend it down in February and report it in March. Even though he's required to report it by the 10th of the next month, there's not really a penalty for failing to report. But the penalty really goes to having excess assets. So that's your focus. You still are always advising someone to report, but the timing of reporting is not as critical. You still want it to be as soon as possible, but you don't want someone to report when the balance of their assets in the month they're reporting is over the limit, because then you're dealing with a discontinuance, and that's a nightmare. So you'd rather have them wait and report for another month, and then um, when they report, by the first of that month, their balance is under the limit. So Medicaid or SSI cannot be discontinued. So here's an example of how he, might use a combination of strategies. So he receives 50,000. He's 62 and receives SSD. Let's assume he's on Medicaid and he only has 3,000 in savings. So he can keep a certain amount of it, because to bring his savings up to the limit. And don't forget that your Social Security check does not count as an asset in the month you receive it. It's income. So even though for that moment you receive that income, your balance of your account goes over this asset limit, it's okay as long as you bring it down by the end of the month to that limit. He can prepay funeral for himself and for his daughter. He can spend some on travel. He wants to keep the receipts. And then he can put some of it into an S&T. So it's an example. You don't have to do all or none. Now, if he was over 65, he could also use a pool trust. He couldn't use an S&T. But since the transfer into the pool trust would trigger a transfer penalty if he needed nursing home care in the next 5 years, he might instead consider prepaying rent, utilities, instead of putting in this 22,000 into a trust. But it's his decision to make about the risk. We've already made this point. If someone delays in doing all this, it's okay. You can still always bring them under the limits. Even if 6 months has gone by and they haven't reported the excess asset, it's just do it now. What Medicaid will do is refer the case to its lien and recovery unit for a possible suit to repay the cost of care in the months that the person had excess income or assets. Now they can send letters to the client and say, pay us 20,000 for the amount of Medicaid services you provided. It's just a letter. It's not a lawsuit. So they don't have to pay it. Um, there's no way that Medicaid can actually recover an overpayment in this situation without bringing a lawsuit. So they're going to look at the cost balance, the cost benefit there, and not bring a lawsuit if it's not going to net them much. So people should not be intimidated by those letters. They do not have to respond to those letters. Now, one thing you want to think about for someone who's on Medicaid, they're not on SSI, they're getting a sizable lump sum. You want to think about, do they really need Medicaid? Let's say it's it's non-MAGI Medicaid, so assets count. Some people think they need Medicaid because they've always had it, but actually, if they had the Medicare Savings Program, which pays their Part B premium, now with that gets them extra help for Part D, and it has no asset test. When they receive the lump sum in this program, it would count as income in the month received, and they wouldn't be eligible for it, but it doesn't really matter because once they save it, there's no asset limit. So you want to ask those questions. Are they using Medicaid for home care? Then that's a no-brainer. Yes, they need to keep Medicaid. But if they're just using it to wrap around Medicare, reduce some of their costs, the Medicare Savings Program can reduce some of their costs, and now they could afford a Medigap policy with their savings. So maybe that's a good alternative. Just don't assume that people need Medicaid. Now we're going to talk about SSI. Which we've talked about a little bit. So unlike community Medicaid, a transfer of assets will trigger a harsh transfer penalty unless it's an exempt transfer. And in SSI, the transfer penalty means SSI is suspended. It's actually terminated for up to 36 months. Now, some of the exceptions to the penalty are, just like in Medicaid, if one is under age 65 and has a disability, one can deposit it into an S&T, either pool trust or individual trust, but not over 65, 65 or over. This is a big difference with community Medicaid. Because in community Medicaid, we talked about you could still transfer into a pool trust. You just have to know that there could be a penalty if you go into a nursing home later. But that's not the case in SSI. There is a penalty on transferring into a pool trust. You can also transfer it into a S&T for another disabled individual under 65, or transfer to a disabled child of one's own of any age, even over 65. And you don't have to use an S&T in that situation. It could just be a cash transfer. So that's always important to ask. Does the client have a child who has been determined disabled or who might be determined disabled? So what is the transfer penalty? We're dividing the amount transferred by the SSI benefit rate, including the state supplement or SSP. So example, I know you have a poll going. I'll give you a second. But I'm just going to talk anyway. Let's say the SSI benefit rate is $858 now. So if you transferred 8,580, that's 10 times 858. That's a 10-month penalty that you're disqualified from SSI for. Now, if you transferred $31,000, then your SSI would be cut off for 36 months. If you transferred $100,000, SSI would be cut off for 36 months. After 36 months, you could reapply for SSI because when they do the look back, they'd look back and the transfer was more than 36 months ago. So for all intents and purposes, the maximum penalty is 36 months. So when you're doing planning for someone with SSI, you want to look at, well, how much is this lump sum? Is it, if it's 35,000 or less and the person is over 65, it really doesn't make sense to transfer it or put it into a trust because of this penalty. You're going to lose 31,000 of it. Now, if it's significantly over that, if we're talking, 75, 80,000, 100,000, then it could be worth, you say, okay, I'm going to lose 31,000 in SSI, but because of that, I'm going to now have 70,000 in a pool trust that I can use the rest of my life. So that could be worth it. I mean, this is again cost benefits analysis that you have to do. Now, let's say someone decides to transfer $100,000 pool trust to daughters, to friends, whatever, and spends it down, and then in 3 years goes and it reapplies for SSI. Well, they are going to do a look back, and if their records show that we cut you off because you received this lump sum, they're going to ask where the money went, and you want receipts. So always advise the client to keep receipts, confirm transfers through canceled checks. But if they're willing to take the penalty, then they don't have to worry about using an exempt transfer. I mean, you could transfer it to your child. Yes, there's a penalty, but you're willing to take it and just go off SSI. So here's an example of Sally who won a personal injury award. She's on SSI. She got $100,000. So she decides to put 50,000 into a pool trust. Now, yes, there will be a penalty if she goes into a nursing home in the next 5 years. She knows that. She knows her SSI is going to be cut off. But she now has 50,000 in cash she's very happy about, and she can spend that down over the next 3 years. Now, she'll lose the 31,000 in income in SSI, but she figures, look, I'm saving 70,000 out of this 100,000. So that's worth it to me. And she doesn't receive home care. So she buys a Medigap policy. She applies for the Medicare Savings Program. She gives up Medicaid. And once her assets are down to 15,450, she can apply for Medicaid. At the end of the 3 years, if her assets are now down to 2,000, she can reapply for SSI documenting where the money went. Now, what if she couldn't give up Medicaid? What if the same person receives MLTC or home care services or lives in an assisted living program funded by Medicaid or congregate care? What would you suggest? So in that case, she'd want to keep Medicaid even if she gets cut off SSI. So she can keep Medicaid as long as her assets are under 15,450. So to do that, She might, this is just one scenario, she might transfer a chunk into a pool trust, say 60,000, keep the Medicaid limit of 15,000 and change, and then spend the rest on home improvement, prepaying for funeral. She can buy funeral agreements for herself and some of her family, burial plots for her siblings and kids. She can prepay rent and utilities, and her SSI will be cut off because her assets are over 2,000. She'll receive something called a Stenson notice, and we have a whole article about Stenson, which is a procedure that is supposed to allow someone who had Medicaid through SSI keep their Medicaid by essentially reapplying for Medicaid through the regular non-MAGI Medicaid program. So they get transitioned to from SSI Medicaid to regular non-MAGI Medicaid. And until they submit that renewal, they keep their SSI Medicaid going. The Stenson process should ensure a seamless transition. But glitches happen all the time because the transition depends on the client receiving and responding to a series of notices, which are all visible at this link. So you want to help them manage that process to keep their Medicaid going. And since she's getting community Medicaid, she doesn't have to worry about the transfer penalty, but of course, she needs to know that there will be a transfer penalty if she needs nursing home care in the next 5 years. So we're going to try a little poll again, just to test your knowledge. So I hope you can see it. Oh, people are voting. Good. We'll give you a minute. All right, so the question is Sam receives SSI. Uh, they inherit $20,000. The rent is $500. What more would it help to know? And if you've ever emailed me with a question like this, these are all the questions I always shoot back at you because I can't even start to answer your question without many of these questions. So let's see. Collecting responses. Well, there was some way for me to show you. 73% of people said all of the above. So let's take a look. I'm going to close the poll. Oh, so now you can see the results, what people are saying. Okay. All right, so I hope now you can see this screen, and we're just going to talk about this. So you want to know how old is Sam? Absolutely. You have to know if Sam is age 65 or over or under 65 to know whether a pool trust or an S&T is an option, right? So a lot of people were right on that. Now, even though it's an option to use, let's say the person's under 65, just because they can deposit the whole settlement into the trust, now we want to bring in what you learned in part 1 of this seminar. Is a trust a good idea? Because what will the trust do with the money? So this is bringing back part 1. The rent is $500. Person's on SSI. If the $20,000 principal is used to pay the rent and spent down in 40, it's going to be all spent down in a little over 3 years. It'll be gone. Plus, SSI will be reduced by $257 a month. It's the lesser of the actual payment or 1/3 of the federal benefit rate, which is $257. So Sam will lose over $10,000 in SSI by having the trust pay $20,000 of SSI. So you're really dissipating like half the benefit of this inheritance. So you want to explore other options. One question that you need to explore other options is to know at what age did Sam become disabled. So those of you who answered that were right, because you want to know if Sam was disabled before age 26. If so, I forgot to put that down here. Sam may put $15,000 a year in the ABLE account, and the ABLE account may pay rent, and SSI will not be reduced. So that would really stretch out the benefit of the trust. If Sam was not disabled before age 26, then you still have that, you can't use an ABLE account. And then you want to look at, are there better expenses that the trust could pay that wouldn't reduce SSI? Cable, phone bill, transportation costs. Person could buy a monthly transit card in New York. Could maybe there's, I don't know if Lyft has prepaid cards or Uber. Um, but you can get creative on those things. Again, shelter and food, and those slides are in the beginning of this slide deck, would count against, those would reduce SSI. Now, if it turned out when you asked Sam the age and you found out they're over 65, 65 or over, then you want to avoid using a pool trust, especially with such a small amount of money, like $20,000. It's just not worth it. Um, oh, all right. Well, this was another poll, but it's basically, well, what would you want to do? And it would just, you'd want to, you have to see whether the person wants to give up SSI and spend it down, but keep Medicaid, or they really need that SSI. And again, with a $20,000 lump sum, I wouldn't advise giving up SSI because it's just going to negate any benefit from your the lump sum. I would only think about giving up SSI if it was quite a bit more than that. So then you spend it down quickly to the SSI limits. And one of these options is to prepay rent, which would not have a transfer penalty. You can write a check for $5,000 to the landlord, get a receipt for 10 months rent, and it's not a transfer because it's for full value. Now, in one case I used this for, the client was very smart, and even though she had prepaid 10 full months of rent, she decided to use the credit over 20 months. So she just would draw down $250 a month from her advance credit to pay her rent because she kept her SSI going and she could pay some rent, and she'd rather subsidize her own rent for 20 months instead of having it only last for 10 months. So that's a creative planning strategy. The same thing for a cell phone or cable. You could draw it down over a period of time and just subsidize um, your own services. Now, if it was, again, you want to take into account the amount of the lump sum. If it's $100,000 and not $20,000, then you want to be asking, does a person really need Medicaid? Maybe they could use the Medicare Savings Program instead. But that those are important questions to ask. All right, now we have about 20 minutes on all the other benefits. Let's talk about the veterans pension. Because of changes and new transfer penalties. Before December 2018, there was no asset limit for the veterans pension, and now there is. So the asset limits, they're using the community spouse resource allowance from the Medicaid spousal impoverishment rules. So at least they're, fairly high relative to what we're used to in Medicaid, 127,000 and change this year, going up a little bit next year. But this is the combined asset limit for the claimant's claimant's assets and their spouse's assets. Plus, they're defining assets to include annual income, which is counterintuitive. So you need to calculate their annual income and add that in. So that makes the asset limit a little more challenging. What are excluded assets? The primary residence is excluded with up to 2 acres of land for you folks outside of New York City. If they have more than that, the excess land counts against the asset limit. And the home is exempt even if they're not living in it, if they've gone into a nursing home or other care facility, or even if they're living with a family member because of needing care. The car is exempt, appliance is exempt, personal effects consistent with a reasonable way of life. I don't think they mean Donald Trump's lifestyle. So if assets exceed the limits, one may spend down assets for fair market value in ways we've just discussed, but you may not transfer assets and qualify for veterans benefits. If you did spend down, you would be eligible on the date that you brought the assets under the limit. If you didn't spend down and assets exceed the limits, benefits are discontinued effective the last day of that calendar year, unless I think it's effective until the last day of the calendar year. No. Oh, sorry about that. No, maybe the discontinuance takes place at the end of the year unless you've spent it down in this same year. That's what it is. And there is a transfer penalty if you transfer assets, maximum length of 5 years. The penalty is calculated similar to the Medicaid nursing home penalty, but with a much less favorable denominator. You're dividing the excess assets transferred by only 2,230. And that's the number of months of the transfer penalty. And there is a 36-month look back preceding filing of a new claim, although it will not go back before October 2018. So right now, there's only like a 1 year look back until, time marches forward. Two exceptions to the transfer penalty for the VA. If the transfer was result of fraud or an unfair business practice, like a shady marketing of an annuity or financial products in order to get the VA pension. I really don't know exactly what that would mean. I think it would be very narrow. And if the veteran or their spouse transfers the money to what is essentially a third party trust for a child incapable of self support, so that seems similar to a third party supplemental needs trust. But what is missing here? There is no exception to the transfer penalty for a veteran or spouse to transfer excess assets to an individual S&T for the veteran's own benefit. I mean, to me, this is just such an unthinkable, departure from what Medicaid and SSI have had for many, many years. As in Medicaid, if you return the assets, it will reduce or eliminate the penalty. So remember, here's another question to add to your checklist. If the person receives a VA pension, everything we said before about using trusts and transfers, you've got to rethink all that, because what's allowed for Medicaid and even SSI is not allowed if the person receives a veteran's pension. So it's very important to keep that in mind. SNAP or food stamps. So if somebody receives a lump sum and they receive food stamps, generally a non-recurring lump sum is exempt. And this is in the food stamp source book. You have a link in your materials. So this would be an income tax refund, a retroactive check from benefits, or lump sum insurance settlements. It doesn't specifically list other lump sums like inheritances, lottery wins, lawsuit settlements, but it does say including but not limited to. So, that's an old legal trick that we say that it's not limited. So it should be exempt. Plus, many SNAP recipients don't have a resource limit anyway. People who are age 60 or over, or who have been determined disabled, have no resource limit as long as their gross monthly income is under 200% of the federal poverty line. And the limits are here. That's about $2,082 a month for one person, $2,820 for a couple. So if there's no resource limit, because they fall in those income brackets, then winning a lump sum wouldn't affect them. And the definition here, that it's a non-recurring lump sum, does not count as income. So that's encouraging for people with SNAP. Now, if their income is over those limits, then there are resource limits, and they're different depending on whether they're under or over age 60, or whether there's a family member who's disabled. So in those cases, if you have a resource limit, then yes, the lump sum would disqualify you from SNAP. So you just need to have these figures in mind. So if there's no resource limit because your income is under that 200% federal poverty level and you're either age 60 plus or disabled, then there's no transfer penalty for transferring a resource, whether to a pool trust or a supplemental needs trust or otherwise. But if a resource limit does apply, there is a penalty for a knowing transfer 3 months before the application or after the application's approval. And that penalty disqualifies you from SNAP for up to 1 year, depending on the amount transferred. It's a sliding scale. So, what's the moral of that story? If the person is not yet on SNAP and they're getting a lump sum, wait for 3 months before they apply for SNAP, because then there's no penalty. Housing subsidies. So first we're talking about SCREE, the Senior Citizens Rent Increase Exemption, and DREE, the Disability Rent Increase Exemption. Just a little bit about these programs, and I'm not sure if they're outside New York City or if they're only in New York City. They freeze the rent for people age 62 or who have been determined disabled if their income is under $50,000. The city pays the rent increases to the landlord through a property tax abatement. So in this program, what is not counted as income are lots of lump sums, gifts, inheritances from non-legally responsible relatives do not count as income. That's good news. Personal injury damages award, income tax refunds do not count as income. However, some lump sums do count as income. So lawsuit settlements other than personal injury damages award, lottery wins, capital gains from selling stock, trust income. So there is no asset limit for SCREE or DREE, so there's no look back or transfer penalty, but dividends and interest do count as income, and as it says, capital gains count as income. So if someone receives lump sum income and there is some relief, and if the lump sum is one that counts as income, then here's how the program handles it. Renewals are only done every 2 years, and they are based at applications and renewals are based on income in the preceding calendar year. So, in the application and in the renewal every 2 years, you must report the prior year's income, including any lump sum received in that year. Now, if that lump sum brings your income over, then your SCREE or DREE can be terminated the year after receipt of the lump sum if that's the year that your renewal is due. Or if increased income brings your rent under a third of your household income. But here's the good news. You can reapply the next year. And assuming you're eligible then because your previous year's income is back to your regular amount. You didn't receive a lump sum now in the previous year. The tax abatement will be reinstated at the old level as if the rent exemption had not expired. So it's essentially suspended for 1 year, except it does require that you remember to go and reapply. Now, I didn't know about this until I prepared for this training. So here's an example that's so in 2019, Lou settles a discrimination suit and gets $50,000. She has DREE. Her rent is frozen at $800, but her real rent is $1,200. So the next year, she's up for her renewal and she must report that settlement, and it is countable. And it puts her over the income limit, and DREE is terminated, and now she must pay the $1,200 in rent. But the next year, January 1st of the next year, 2021, she reapplies. In 2020, her income was below the limits because or it's under 50,000. So now the tax abatement will be reinstated and her rent will go back to $800. So this is really important to know. Yes, people will take a hit for up to a year, but then it will be reinstated. They don't have to reapply and start all over with a very minimal tax abatement. Section 8. Section 8 public housing or a federal rent subsidy. They generally limit rent to approximately 30% of net countable income, which is calculated by a very complicated formula that deducts some medical expenses, is different based on age and disability. I'm not going into the formula, but what happens if they get a lump sum? So there's no asset limit for Section 8, but Section 8 will impute interest on assets over a threshold of $5,000 as income. So, and then if interest is income and rent is based on income, that means assets that are over 5,000 could raise your rent because of that imputed income. So let's look at how that works. First, we're just going to look at what does not count as income. So the regs say that lump sum additions to family assets don't count as income. So you can keep or transfer inheritances, temporary, non-recurring, or sporadic income, including gifts. And the New York City Housing Authority manual specifically includes one-time lottery wins, retroactive unemployment checks, insurance payments, workers' comp, reimbursement for medical, retroactive Social Security or SSD, and settlements for personal or property losses. So that would be personal injury, tax refunds, capital gain. So that's all good news. But if something is countable, what happens? So they will impute income of the larger of the actual income generated by the asset or 0.06% of the amount exceeding 5,000. Now that's a very small amount, and that was changed a few years ago. It used to be much higher, and they finally, when interest rates dropped, they finally lowered the amount. And all the sites are here and in our manual. So you'd have to have a lot of money for 0.06% of the excess over 5,000 to affect your rent. So that's basically the answer. I mean, it's really very, very little. I mean, even if it raises your rent $1 or $2, that would still be based on a very high amount of assets. So, and there is no current asset limit, but a 2016 federal law set a $100,000 limit for Section 8, and I believe for public housing. But the last time I checked, there were still not regulations on this. So as far as I know, this is not yet in effect. The only limit there's in effect now is that if assets are over 5,000, then they'll deem a certain amount of interest on the amount over 5,000 as income, which could increase rent. And if you transfer assets over 5,000, then they'll impute income in the same amount to the transferred assets. So it's really a very minimal amount. So Wow, we are just 5 minutes ahead of the deadline. I know this was a massive amount of information. This manual uh, explains all this in a different format. Now, it hasn't been updated for the very new stuff that I corrected about ABLE accounts in there. So use this information for that. Um, and once again, now I also posted yesterday. I'm just going to show you oh, our website, New York Health Access, which I hope you're familiar with. So in the news section, the article about this webinar, we posted a FAQ. There were probably 50 questions asked, on the GoToWebinar last time. And please download this because I answered all the questions. Uh, And you can also view part one of the webinar here. So we don't have time to answer the questions here. Please review the materials, review the FAQ, and if there are new questions, I will eventually try to answer them. We thank you for participating, and I believe you're going to be getting a survey of for your for you to show whether you learned anything today and the last webinar. So I hope you'll respond to that. And thank you all for participating or closing the webinar.